So you got your Canada visa refusal. I know it's very hard, but don't worry. It happens to many people. Here's the good news. If you're determined to get your visa, appealing the decision might be your next step. And I'm here to help you. Hi, my name is Morteza, a regulated Canadian immigration consultant, and welcome to Visa Mondial YouTube channel, where we help a lot of people like yourself turn their Canadian dream into reality. We've helped over 1,000 applicants in your situation, and today I'll walk you through how to turn your visa refusal into an approval. So let's break down the steps to appeal in the Federal Court of Canada, and I promise you, at the end of this video, you will have a clear idea of how to move forward. All right, let's start with the basics. A judicial review in this situation, if you have a refusal, is asking a federal judge to review Immigration Canada decision and see if they have messed up. Now, you can't just appeal for any reason. There are specific grounds, like if they made a factual or legal error, or if they misapplied the law, or they're just plain unreasonable. Let me tell you a story about one of my clients. Her visa application was refused. And honestly, the reasons made no sense to me at all. The officer claimed she wouldn't leave Canada at the end of her stay, and that she's divorced and she has no kids and she lacks ties back home. They even questioned her reason for visiting, which was to see her brother, like it wasn't reasonable enough. But here's where it gets really frustrating. They completely ignored some major ties she had to her hometown, like her 8-year job and her approved leave of absence for the duration of her trip, an apartment she owns, and family in her hometown. It was clear she wasn't planning to ditch everything and stay in Canada. So we took the case to the federal court, and right before the hearing date, IRCC decided to settle out of court. They took another look at her application, and thankfully they approved her visa. After all that stress, she finally got to visit her brother in Canada. Here are all the steps you need to take. If it's starting to feel a bit overwhelming, it's absolutely normal. Don't worry, I'll explain it completely for you. You're not alone here, I'm with you. And by following the steps, you will know exactly what to do. So, you have that dreaded visa refusal letter. Painful. I know, I've been there. I know how it feels. But before you start panicking, take a deep breath and read the letter carefully. It's like a detective story. You need to figure out why your application was rejected. The real fun begins with GCMS notes. Think of it as the secret sauce, the hidden details behind the decision. You can request these notes from Immigration Canada, and once you have them, read them line by line. It's like a treasure hunt, and you're looking for clues to understand why your application was denied. Of course, you can do it on your own, but you might want to decide to work with a legal team with tons of experience in immigration law, as immigration law is like a maze, right? And it's constantly changing, and one wrong move could cost you a lot. So hiring a lawyer or judicial review is like having a seasoned guide, and they know the ins and out, and they can really help you through this situation. And also, you don't want to get multiple visa rejections, as they could hurt your chances in the future. So don't risk it. Get a lawyer and let them handle your legal jargon. Okay, so you've got your lawyer and you have understood the reasons for the refusal letter from your GCMS notes. And it's time to take the next step, filing the application for leave and judicial review. This is basically a formal request to the federal court asking the permission to appeal the refusal decision. So you'll need to include some key info, like the date your application got denied, why it was refused, and your reasons for believing the decision was wrong. Just a heads up, there is a pretty tight deadline for submitting this application. If you apply from outside Canada, it would be 60 days. And if you apply from within Canada, it would be only 15 days. So don't wait around. The clock is ticking and you're missing your time. Make sure that you respect deadlines. Now, who is who in this legal drama? In this legal battle, you are the appellant. You are the one challenging the decision. On the other side, we have the respondent, which is the Minister of Citizenship and Immigration, or IRCC. Once you've filed your application, make sure to let IRCC know you're going against their decision by sending them a notice of application. Once you file your application, IRCC will send some written reasons. It's basically a breakdown of why your application got refused. Think of it like a report card, but for your visa application. These written reasons are actually super useful for building your case. They'll give you a clear picture of what was wrong in officer's eye in your application, and you will know what you need to do to fix it. So once you get them, make sure to really go through them. Look for the key details that could be game changer for your case. Now comes the fun part. Building your case. You'll need to put together a strong application record. Think of it as your legal toolkit, packed with evidence, arguments, and so on. You've got to show the court why IRCC's decision was wrong. So gather all the key documents and supporting evidence and put them in your application. The most important part is putting together a solid legal argument. So what is a legal argument? Legal argument is explaining the relevant law in your application and how those legal pieces would apply in your case. It's kind of like writing a persuasive essay, but with a bit more legal jargon. The stronger your argument, the better your chances of success. Here's a basic example of a legal argument. As you check out this sample legal memorandum, keep in mind that these are pretty basic. It's just to give you an idea of how to put your appeal together. In reality, a solid legal memorandum digs much deeper than what you're seeing here. It dives into relevant case laws that can boost your arguments. It can be up to 30, 40, 50 pages sometimes. So be sure to find case laws that match your specific reasons for refusal. You can search them on Canly website if you want. The right ones can make your case much more convincing. To write your legal argument, you need to have a solid grasp of immigration laws and relevant case laws. So you should know how to search and how to draft that document. So again, it's super important to ask for help from someone who knows these kind of stuff. Hiring a lawyer would be the go-to decision here. Your application record is crucial and can significantly impact the outcome of your appeal. Once you've written your memorandum of argument and gathered all your application record, it's time to submit them to the registry of the Federal Court of Canada. Here is what your application record should include: your application for leave, the visa refusal letter, the written reasons, affidavits, and memorandum of arguments, as I explained. These are the key documents you will need. Now, if you got the reasons for the refusal before filing, you've got 30 days to submit your application record. If you got them after filing, you've got 30 days from when you received them. Sometimes instead of going through the full court battle, which takes time for Immigration Canada lawyer, IRCC might offer a settlement. So they'll come forward and offer you this kind of settlement. This means they will consider your application without a court hearing. It's like a compromise when you drop your case to appeal in exchange for a fresh look at your application in Immigration Canada, like IRCC. So they decide to take a look at your application and instead you drop a case in judicial review system. Here you can see a real settlement offer for one of our clients. Accepting a settlement offer and rejecting the settlement offer are your options now. Accepting the offer can save you time and money, but it's important to weigh the pros and cons with your lawyer. Sometimes we decide not to accept it. It depends. After both sides have presented their arguments, The judge will review everything and decide whether to grant you leave to move forward with the judicial review or not. You'll usually get a decision in about 60 days, but sometimes it might take longer. Here's where it gets interesting. If the judge denies your application, that is the end of the road, and your case will be closed. But if they grant you a leave, it means your case has merit and you'll move on to the next step. Next step would be a full hearing to present your argument in details directly to the judge. If the judge gives you the green light, you will get a notice of appeal with the date, time, and location of the hearing. Most hearings these days are online, but sometimes they could be in person too. At the hearing, what happens? At the hearing, you or your lawyer will explain why the original decision was wrong, and they would back it up with the evidence. Be ready for questions from the judge, and remember, IRCC's lawyer will present their side of the story. They will come to defend their decision. After the hearing, you will have to wait for the judge's final decision. This could take a long time, sometimes up to, let's say, 6 months or 8 months. And there are two possible outcomes. Maybe the judge will take your side or IRCC's side. If the judge sides with the IRCC, your appeal gets dismissed. Unfortunately, this means your application will not go forward for redetermination by IRCC. But if the judge agrees with you, it's a win. Congratulations. Now IRCC's decision will be overturned, will be set aside, and court will send your case back to IRCC, but another officer now has to go and take a look for re-evaluation. In this case, if you win the appeal, IRCC will ask you for updated document. So we call it usually update. And a new immigration officer will take another look at your case. They will come and ask for your bank letter, or maybe if in a study permit case, they will ask you to update your letter of acceptance and so on. And then they will decide at the end on your application. That wraps up the whole process from start to finish. Appealing a visa refusal is tough, both emotionally and financially. You'll have court fees to cover, you'll have to hire a lawyer, which would add cost for sure, and some little maybe hidden costs that you might have here. Legal fees, depending on how complicated your case is, would be different, but it is usually around 2,000 to 4,000, I would say, for most cases. The whole process can take several months. It would take between 3 to 12 months. But in this case, patience and persistence can make it possible. So there you have it, a full breakdown, as I promised, of how to appeal a Canada visa refusal, step by step. It can be a tricky process, but with the right info and guidance, it's definitely doable and it's definitely worth it. If you're thinking about appealing, it's a good idea not to do it alone. Get in touch with us or with a qualified lawyer who can help you through it and give you the best shot at success. If you're ready to make the next step in your immigration journey, click the link below to book a consultation session. And in that session, we will tell you how much of a chance you will have to get your Canada visa. If you like this video, please subscribe and like it so the YouTube algorithm will show you more videos like this.